Good afternoon, and hello again. I'm going to talk to you about establishing truth and economic proof, which is a bit of a shorter title than the one that was announced in the program. And actually, this covers my presentation better than the title in the program. And I want to point out that I am an academic, but I'm also an honorary judge, and it is in my capacity as a judge that this topic of economic proof became especially relevant. And so I switch hats almost. As a judge, I'm confronted with these very difficult issues of economic proof, and then as an academic, I try to say something intelligent about it. So what I'm presenting to you today is a bit of a mixture of those two views. Let me see. So this is what I'm going to do, give you a bit of context. That also talks about what is proof. What is truth first, and what is truth in court. Then talk about proof, talk about economic proof, zooming in a little bit further on prospective economic proof, then zoom out again with some final remarks. So this is the context that we're talking about today. I'm talking about the administrative law context. So that's an administrative agency, a competition law agency, or a regulatory agency applying competition or other economic forms of law. So I'm not talking about the criminal system, I'm not talking about the civil law courts, this is the administrative law courts. And what is defining of that relationship is that there's always, there's a relationship between the state and the individual. So there's the state, that means the administrative agency, and the individual, usually an undertaking. And that relationship is always de jure, unequal. That means the state has the prerogative of power and the individual does not. Now, in competition law, you often see that it is de facto more equal. If you look at the competition authorities, they might have very good people there, lots of economists, lots of lawyers at their institute. But if you look at the big firms that are actually being charged with infringing competition law, they also have this battery of lawyers and economists that are actually probably being paid much more than the ones at the competition authority. So you have a relationship that is de facto more equal, but is still de jure unequal. And that, I will come back to that because this is an important point. The context also means that the administrative, before the court steps in competition law cases, the administrative agency has already taken a decision. That's completely different from the criminal system or the civil system, where the judgment is actually the first time that the facts and everything is being looked upon. So the court reviews the decision. And of course, economic assessments are part of that review. Now, this slide talks to you about truth, because my point today will be that because competition law is pretty much economic law, it is more difficult to establish the truth in this type of procedures than in normal administrative procedures. But to be able to understand that line of reasoning, we need to talk a little bit about concepts of truth. Now, this is very philosophical. Bear with me, I'll make it very simple. There's basically two main theories of what is true, what is truth. Again, there's the correspondence theory that says a statement is true if it corresponds to what we see. So, for example, I can see that there are a girl and a boy sitting in the first row, and if you see the same thing, oh no, if that is really the issue, then that is true. But there's also the coherence theory that says, hey, I see two people sitting there, and if we all agree that it's a boy and a girl, then that is the truth. That's the coherence theory of truth. It's an intersubjective theory. Now, what the court's point usually is, and I'm talking about the administrative court system, mostly on the continent, the French-influenced administrative law system, the court will want to establish a correspondence. So the facts that the courts want to use in their case, in their judgment, need to correspond to the truth that is actually out there. But of course, it is very difficult to actually obtain the complete 100% truth in any judgment. So the court uses this idea as a regulative idea. Correspondence primarily, but coherence is important as well. So establishing truth in court means that it's a process of establishing or proving a historical occurrence, something that actually happened in a procedural context. So we want to know what actually happened, where those two parties actually at that meeting where they discussed the prices. You want to establish that before you can actually uphold the agency's decision. in the Romanian system, and I've talked about this with some Romanians, apparently they have the same idea. The Romanian system of administrative law is pretty much based on the French system. The French system is about substantive truth, as is the Dutch system, and as is the European system of administrative law. And it's the same in the Romanian system. I've put presumably because I don't speak Romanian, as you noticed earlier. So I'm not completely sure about this. Now, why is this important? Why do we need the substantive truth, so the truth that is actually corresponding to what happened in the past? Why do you want that truth in your judgments in administrative law? Well, that is pretty much because of this de jure difference in power between the state and the individual. So you want to uphold the objective law because of the difference in power between the state and the individual. In French, it's the recours objectif. My French is also it's not as bad as my Romanian, but still it's not fluent, but it's the recours objectif. You will want to have the objective truth, the substantive truth, underlying your judgment because of this difference in power. But you could also say it's also important from the point of view of individual judicial protection. I will not go into that, but when I write out my paper for Adriana, then I will deal with that a bit more extensively. Now we've established what the truth is. The truth is that which corresponds to that which actually happened, and we call that the substantive truth. We can talk about the question, what is proof? Or what is evidence? And here I run into a problem because in Dutch, we have one word and its meaning is both proof and evidence. I'm not sure how that is in Romanian, but in English we have two words saying pretty much, for me, still difficult to grasp the exact differences because in Dutch we have one word using the same, or connoting the same concept. Okay, so proof, economic proof, is part of the bigger group of general proof. So that means, what is then economic proof? Well, and that depends on your answer to the question, what is economics? Is economics that which pertains to the economy? Or is economics the use of a specific method? Doesn't really need to bother us here because in competition law it's both. Competition law is market law and therefore pertains to the economic interactions on the market. But in competition law it's also the economic method used to prove something, a fact. So it's both in competition law. So we have an administrative agency, the competition authority, and it takes a decision. That decision is appealed to the court. Then what does the court do? What does the court do with that decision? And where is proof in this picture? So this is pretty much a graphic illustration. Of course, it's stylized and simplified, but this is what the court does. The court looks at the interpretation of the law. Let's start there because it's the most easy. So the court says it looks at the administrative agency's decision, the competition authority's decision, and says, well, you interpreted the concept of abuse of dominance in a completely wrong way. And the court does that, it rectifies that because it is the sole power of the court to actually interpret what the law is. But on the other hand, there are the facts. So it is about, has the administrative agency used the correct facts? Are those the facts that correspond to the truth? Are those the facts that give me the substantive truth? And the court reviews that generally fully. So in administrative law, the court can say, okay, you guys say, well, let's talk about color there. I say, so the administrative agency says, I think that jacket is red. And then the other party says, no, it's blue. Then as a court, I'm going to actually discuss whether or not the jacket is red. Now, in civil law, both parties might agree that the jacket is green, and then I, as a court, have to accept that the jacket is green, even though I'm sure that it is red. In administrative law, I would never accept the jacket being green because I know it is red. So it's a full review of the facts. And proof in this scheme only relates to the facts. So it's a full review of proof, or of evidence. Let's not go there. Then in between, we have the mixed questions of law and facts. We call them assessment questions. In English, they usually call mixed questions, but in other languages, it's called assessment of facts in light of the law. And there, sometimes the court steps back a little. It gives a little room to the administrative agency, especially when we're talking about complex assessments. It will step back, it will review in a marginal way. Not completely marginal, but something like a marginal review. So you have full review of facts, full review of the proof, maybe less intensive review of the mixed question, and of course a full review of the law. So proof, as I said, relates to facts, historical facts, and the court uses what can be termed yardstick rules to discuss that in a judgment. So it uses the concept of the standard of proof, which means that the court decides how much should I be convinced that this actually happened out there before I can use these facts as the basis of my judgment. There's the burden of proof, not that important here, and then there's the standard of review. And as I said, the standard of review is a full review of facts. And all that is geared to establishing the truth of the facts. Now, it's pretty easy to follow, isn't it? But it does become slightly more complicated when we talk about economic proof, because economic proof relates to complex facts. For example, what is a relevant market? Establishing a relevant market is not as easy as establishing whether or not the jacket is red. Establishing a relevant market entails lots of other questions. It entails the concept of the substitution of demand and substitution of, what's the other word? Supply. Thank you very much. Also, economic proof relates to the application of models and theories. If you want to know what the relevant market is, you usually, at the competition agency, will use the SNP test, the small but significant non-transitory increase in price. That's a model. And the model itself becomes, it's a very accepted model, but it's still a model. And it becomes part of the chain of reasoning of the administrative agency. But it's not a simple, it's a model used to establish a fact. This is the relevant market, which is in itself complex. And then that begs the question, are the models and theories themselves facts? Can you review them as a court as being facts? And that means, should you establish the correspondence, the substantive truth of those models and theories, which sounds a bit silly. Because a theory is nothing more than, well, a model is a model. It cannot be the thing itself. So that means that also the yardstick rules become more difficult to apply. Because what then would be the standard of proof? How do you as a court review whether the model that has been used is the correct model to be used? Or do you actually see the model as a fact, and do you review it as a fact, as intensively as you would a fact? What will be your standard of review in these cases? And that means also that whether or not you can come to the substantive truth, which is the aim in administrative courts, becomes more difficult. So let's go back to what the court does and relate that to economic proof. In complex economic assessments, and this is standard case law of the Court of Justice in Europe, it's in Luxembourg of the European Court of Justice, but it has also been used in several national courts in Europe. Complex economic assessments, that's the middle one. The Court of Justice has said, yes, we are going to give some leeway to the administrative agency because this is so difficult. The administrative agency has to decide how to deal with that, and I'm going to review that marginally, so only when they're completely wrong, I'm going to overturn that. But it would be my contention that this concept of complex economic assessments leading to a margin of appreciation for the administrative agency is also applied in real life to establishing facts. So it's not limited to the complex, to the assessment, to the mixed questions of law and fact. It's actually extended upwards or downwards, depending on your view, towards the complex facts themselves and the models and the theories that are used. And you might, but that line is dotted because I'm still not sure about that, you might also hold the view that even the interpretation of the economic law would be reviewed by the court slightly less full as it would normally, because economic issues play a role in the interpretation of the law as it does in the establishing of the facts. So that is one thing, that economic proof makes it more difficult for courts to reach the substantive truth. But now, in competition law, we also have the concept of prospective evidence or prospective proof. That means, for example, in merger control, you know merger control, when two parties want to merge, you have to establish whether or not in the future something bad for competition is going to happen. So prospective evidence means that you need to have evidence, you need to have proof for something that has not happened yet. So prospective evidence concerns future facts, very complex facts, and that is usually done by thinking about scenarios. So the competition authority might think of 3 or 4 scenarios, saying, okay, if this happens in the real world, then the effect of this merger will probably be this and that. But then maybe the developments are slightly different, and then maybe this happens. And then it chooses a scenario that it will put below, that will ground the decision on the merger. Now, how do you do that? So it's scenarios, but the competition authority might also use consumer surveys. And that usually is presented as being quite objective, as being something the consumer surveys would lead to a substantive truth. But there's something weird here, because if you are asked, what would you do if the price of Coca-Cola goes up? Would you then buy Pepsi-Cola? You're still answering a question about your individual preference in the future. I mean, if it would really go up, maybe you would do something completely different. So even the consumer surveys, which are usually presented as solid evidence, solid facts of something that has already happened, is not proof of a historical occurrence, but something that might occur in the future. Well, and the remedies are in the same vein, might be problematic. So prospective evidence is uncertain, is inherently uncertain. Although, of course, it depends a bit on how complex your case is, whether or not some statement on the future is very uncertain or just slightly uncertain. So that means that the yardstick rules change as well. The review might be a review of the plausibility, giving more power to the agency. But then I have never come across reading how the judges should review the choice of a scenario. How do you review whether or not the scenario chosen by the competition authority is the correct scenario, if all the scenarios are in the future? And then a very specific issue, which I just want to point to, but not go into detail because I only have 3 minutes left, is how to review expert evidence. A lot of the evidence brought forward at the competition authority will be presented by economic experts. And then, of course, the other party will present their own expert evidence. And then you have 2 experts saying completely opposite things. And then at the court level, you have to decide which expert is correct. So how do you deal with that? Especially considering that at the court, at least when I'm at the court, we are with 3 judges and we're all lawyers, but we are not economists. We might hire our own economists, but that's costly. And what if our own economist or appointed economist comes up with a 3rd scenario? Then how do I decide which of the 3 experts is right? So do I then take a step back and only make a decision on the expertise of the expert, for example? Or do I grant the competition authority a margin of appreciation, and as long as its expert evidence stays within some boundaries, I will accept that? So it becomes an almost procedural review and not a substantive review, which takes us further and further and further from the truth. In the Dutch context, our Court of Appeal in competition cases has actually said explicitly that when a prospective scenario is involved, it can never lead to the substantive truth. We have to settle for a different truth. And they have given some rules on how to deal with that, but it still does not answer all the questions. So that leads me to my final slide. This is a complex relationship, truth and economic evidence. And you might think, why is this relevant? Well, it is relevant if you uphold the idea that in administrative cases, the administrative court should aim for the substantive truth. If you discard that idea, then this is not problematic. But if that idea is still solid and foundational in your administrative law system, then this becomes a problem. And my contention would be that if you think about this hard and long, you can tease out where exactly the uncertainties lie and actually bring it back, actually reduce the uncertainty to the real uncertain issues, accept that the uncertainties will be there, and then devise a solution for that. And I've thought of solutions, but I don't think I have time to present those. So thank you very much.
Thank you, Professor Gerbrandy.